Use headphone for better experience.
He was the smiling face on cereal boxes and billboards, the running back who seemed to glide above the grass. And then one June night, Los Angeles held its breath as sirens stitched the city together, and a white Bronco became a national mirror, reflecting fear, fame, and the question no one could dodge. Did O.J. do it? On the evening of June 12, 1994, a Sunday sinking into ordinary darkness, the city spread itself out the way Los Angeles does, all glitter and angles and long streets that pretend they go on forever. At Bundy Drive in Brentwood, a small courtyard hid a doorway half swallowed in shade. Nicole Brown Simpson had come home after dinner with family. Her 2 sleeping children lay upstairs. The night smelled like jacaranda and just-watered lawns. A neighbor walked a dog that would soon be famous for how it led people toward horror. Across town, O.J. Simpson prepared for a red-eye to Chicago, a golf outing and business in his future. The kind of schedule that, on paper, made sense for a man whose life had divided itself into neat panels. Football, commercials, movies, a kind of smiling retirement. Lives often look like that right before they fall apart. What happened at that walkway took only minutes. The ferocity would later be measured in blood spatter patterns, and knife wounds counted like beads on a terrible rosary. The first to hear something were not people but dogs. One would whine and tug, and then a chain of ordinary citizens. Neighbors, a couple out late. A man named Tom Lang, who would become known to the television audience as a detective with a calm voice and a briefcase of patience, would cross the thin line between the everyday and the unspeakable. When the bodies of Nicole and Ron Goldman were discovered, the scene was a riddle made of red and silence. A glove left behind, bloody shoe prints stepping away, an envelope in Ron's hand, a candle flickering in a window. Phones lit up the night. Detectives Mark Furman and Philip Vanatter. Then Lang, then more uniforms, tape, flashbulbs, questions. A small cut on O.J.'s finger would soon loom. But in those first hours it was the brutality that flooded the room. Before dawn, while the city considered its breakfast menus, the media vans idled. The next day the country knew, because Brentwood was as much a stage as a neighborhood, and O.J. Simpson was not the kind of name that could be kept from the crawl at the bottom of a screen. He returned from Chicago to a changed world. Police came to Rockingham, the estate that had been a kind of sunlit compound for an American story of talent turned into lightness. A bloody Bronco, a trail of spots to the driveway. The second glove near the house, its twin, or so the state would argue, waiting back at Bundy. O.J. stood in his kitchen with a bandaged finger and a kind of floating posture, a man whose body had been trained for decades to say, "I'm fine, I'm in control." He wasn't. He gave an interview that felt like a rehearsal for a defense. The cut, the night, the confusion. Lawyers arrived the way paramedics do when the patient is famous. Robert Shapiro, Robert Kardashian, soon Johnny Cochran, a chorus joined by Barry Scheck and Peter Neufeld. DNA firebrands from the Innocence Project world, and F. Lee Bailey with a courtroom presence both old school and dangerous. On the other side, Marcia Clark and Christopher Darden, prosecutors whose files quickly grew so thick they seemed to bow the desks beneath them, convinced they had a case of overwhelming evidence balanced on a simple fulcrum. O.J. Simpson's blood was at the scene, and the victim's blood was at his home and on his car. Then came the Bronco, and with it, history in the form of spectacle. On June 17, 1994, as the NBA Finals paused and highways emptied, people gathered around televisions to watch a slow-motion pursuit that looked more like a procession, as if the city were escorting a myth toward its reckoning. O.J. In the back seat with a gun and a friend, Al Cowlings at the wheel. The freeway glowed with cruisers. On overpasses, crowds held signs, shouted support or disbelief, waving as if greeting a parade. The feed was a heartbeat on every network, the kind of communal hypnosis usually reserved for moon landings or national mourning. The Bronco rolled into Rockingham at dusk, and the night exhaled. Surrender. Handcuffs. The mugshot that would later be darkened on one magazine cover, a choice that would inflame a nation's arguments about race, media, and the stories we tell with our lenses. Arraignment. Plea. Not guilty. A bail that felt both massive and, given the defendant's fame, insufficient to restore the everyday world. Then discovery, motions, the fierce little wars that precede the public one. The judge, Lance Ito, would become almost as famous as the lawyers. His courtroom a televised theater where every objection had an audience and every sidebar a suspenseful pause. The cameras, allowed in a decision that felt modern and democratic at the time, turned the nation into a jury of millions. People would later say they knew more about DNA because of the Simpson trial than any science class had given them. They would also say they knew more about racial fault lines, police credibility, domestic violence, and the way celebrity works as both armor and magnet. Jury selection took weeks, an exercise in anthropology as much as law. Questionnaires long as novellas. How do you feel about the LAPD? About celebrity? About domestic violence? About the death penalty? About DNA? The panel that emerged, 10 women and 2 men, primarily black, would be shuttled into sequestration, a living experiment in isolation. No TVs, no news, no conversation even with hotel staff beyond the transactional. They would be the guardians of silence in a country screaming at the screen. Opening statements began like a door flung wide on a storm. Marcia Clark's voice, clear, unflinching, promised the jury a map. Blood drops from Bundy to Rockingham, from the walkway to the Bronco to the bedroom, ties that bound the defendant to the scene with a logic that felt arithmetic. Follow the blood, she said in essence, and the line she drew would become the golden thread of the state's case. Christopher Darden, earnest, careful, spoke of a family shattered, of rage made visible. Across the aisle, Johnny Cochran rose with the rhythm that made even his opponents watch him like a man walking a tightrope securely. He promised contamination, rushed to judgment, a police department with a past, a detective, Mark Furman, who would become a central character whether the prosecution wanted him to or not. If it doesn't fit, you must acquit, he would later say, a rhyme that carried the heavy freight of persuasion disguised as common sense. The evidence took months to present, a mountain of items and testimony. Fibers, a bloody sock found at Rockingham with Nicole's blood. The infamous gloves, one at Bundy, one at Rockingham, said to be a rare Eris-like model. Photographs of bruises from Nicole's earlier calls to police. 911 recordings in which fear crackled like static. DNA charts whose ladders and bands turned the courtroom into a classroom. Shoe prints from Bruno Magli's soles, so rare they were like fingerprints. Limo driver Alan Park recalling a dark house, and then a man moving swiftly toward the front door close to the time detectives said the murders occurred. The prosecution believed the case was iron and gravity, too much weight to ignore. But this was not a physics problem. It was a trial in a city still raw from the 1992 Rodney King beating video and the acquittals that followed. A city that mistrusted its police department with reasons rooted in reality and history. The defense knew that context is not just backdrop. It is air. They cultivated the idea that evidence could be planted or sloppily handled, that a preconceived narrative had guided the investigation like rails, that the LAPD's own procedures had become the defendant's best witness. In late-night living rooms, people picked sides and rarely moved afterward. DNA, then a relative novelty in courtrooms, became a star witness with a monotone. The prosecution's experts explained odds so staggering they had their own gravity, matches so unlikely to occur by chance they felt like fate. But the defense, Barry Scheck and Peter Neufeld, made a meal of contamination. Lab protocols breached, vials not refrigerated promptly, samples collected, and then possibly commingled. They showed photos of swabs and vials as if they were dangerous animals grazing too near one another. They asked jurors to see not the power of the science, but the fallibility of the humans wielding it. And television did its work. Every shaky chain of custody moment was not just a fact, but also an image, and images have a way of nesting in memory like seeds. Then came the glove. Prosecutors asked O.J. to try on the gloves in front of the jury, latex under leather, an odd ritual of courtroom theater. The moment unfolded with the slow inevitability of a chess move telegraphed too clearly. O.J. struggled. He spread his fingers. His hands looked like they were trying to inhabit someone else's skin. "It doesn't fit," someone would later summarize, and Cochran would seize the rhyme that became a closing argument drumbeat. The prosecution would say later the gloves had shrunk due to dampness and freezing, that the latex made the fit impossible, that the spectacle was a mistake. But mistakes, once broadcast, multiply. The glove became a symbol, not just of evidence, the glove was theater, but of the dangers of mixing truth and theater. A lead detective at the Bundy scene, he had discovered the glove at Rockingham. On the stand he was strong, certain, then crumbled when confronted with tapes, recorded years earlier, with racist slurs and boasts about evidence handling. He had denied using the slur under oath. The tapes revealed the lie. With that lie came something larger. The defense invited the jury to see Furman not just as a compromised witness, but as proof of a department capable of planting, framing, or at minimum cutting corners to land the suspect they believed was guilty. For jurors already wary, the tapes were not merely impeachment. They were a lens through which to view everything else. For millions watching, the Furman collapse made the case feel less like a simple DNA mosaic and more like an argument about institutional trust. Domestic violence hovered as both motive and context. The prosecution called it what it was: a history of control, fear, escalating harm. Photos of Nicole's bruised face from 1989. The desperate 911 calls. Friends who described her voicing dread. The defense countered with a warning about character evidence inflaming the jury. That past does not equal murder. That rage at an ex-wife does not prove guilt beyond a reasonable doubt for a double homicide on a particular night. And still, in living rooms, a parallel court weighed what it knew about men who hurt the women they once promised to love. The trial was a prism. What you saw depended on the light you brought. Months bled into more months. Jurors endured sequestration like a long winter without windows. The judge juggled side issues that became headlines. Juror dismissals, personality clashes, eruptions of tired anger. The lawyers grew into their roles so thoroughly that even their lapses, the late arrivals, the exasperated sighs, felt like episodes in a series millions had not asked to binge but could not stop watching. The country learned the syntax of objections: asked and answered. Assumes facts not in evidence. Argumentative. It learned that a sidebar could be a cliffhanger. It learned the names of witnesses who, in a different world, might have lived and died with anonymity, but now belong to the public narrative. Cato Kalin with blonde hair and a kind of shaggy uncertainty. Alan Park, steady and specific. Dennis Fung, a criminalist caught between expertise and the pressure cooker glare. When the defense rested, it had not just attacked the state's story, it had erected its own, a brew of contamination, bias, and a man famous enough to be a target. Cochran's closing was a sermon, a poem, a scalpel. He framed Foreman as the face of the investigation's rot, picked apart lab practices, and gave the jury a simple, memorable anchor. If it doesn't fit, you must acquit. Darden and Clark pushed back with timelines, with DNA math, with tears walking the line between personal investment and professional zeal. The jury disappeared into deliberation with a nation leaning forward, as if leaning could affect outcome. It took only a few hours. In a case that had devoured 9 months of American attention, the decision seemed to come like a summer storm, sudden, electrifying, over too soon. On October 3, 1995, the courtroom filled like a lung. People at work paused to watch. Schools rolled televisions into cafeterias. The clerk read the words, "Not guilty on count 1, not guilty on count 2. The sound that followed was not one sound. Cheers in some places, gasps in others, a complicated braided noise that mapped onto the country's fault lines. In black neighborhoods, many celebrated, not necessarily out of love for the defendant, but as a verdict against a department they believed capable of cruelty and deceit. In white suburbs, many stared in disbelief at what they felt was overwhelming evidence set aside. In living rooms where domestic violence survivors sat, something clenched or opened, depending on the story each carried. Television split screens captured the split. After the verdict, life did not resume. It rearranged. O.J. returned to a world that neither welcomed nor expelled him cleanly. Friends divided. Endorsements were gone. A civil trial brought by the victims' families would later find him liable for wrongful death and battery, awarding damages so large they were symbolic as much as practical. The civil jury, untelevised, consumed a narrower diet of evidence and did not hear the drumbeat of reasonable doubt the same way. Meanwhile, the LAPD and forensic labs across the country etched new protocols into their bones. Evidence handling improved, chains of custody tightened, lab notes more meticulous. The trial had exposed fissures, and institutions attempted repairs in the way institutions do, slowly, imperfectly, sometimes defensively. But the changes were not confined to labs. The culture's relationship with true crime mutated. Court TV, 24-hour news cycles, pundit panels. The Simpson trial accelerated the media's transformation from information conveyance to omnipresent theater. Audiences became fluent in legalese. Prosecutors and defense attorneys became household names with book deals. We learned the pitfalls of televising grief and rage at scale. And yet the ratings taught the networks to ignore what they had learned. The next sensational trial would arrive, as they always do, and the cameras would be ready. People asked each other even years later, "Where were you when the verdict came down?" The question doesn't belong to this trial alone. It belongs to astronauts and assassinations and towers falling. That it attached itself to a murder case reveals how thoroughly the narrative colonized the public square. The reasons were layered: celebrity, race, police history, domestic violence, the novelty of DNA. Each layer drew in a different audience, and the aggregate was a nation watching itself watch a trial. In Los Angeles, the ordinary city went on. The restaurants on San Vicente kept seating lunch. The traffic thickened and thinned as if nothing essential had been shown on television. But beneath the surface, small changes. A police department whose training modules now included not just tactics but reputation. A generation of defense attorneys who took notes on how to question lab techs into uncertainty. Prosecutors who learned that jurors require not just facts, but an answer to why those facts can be trusted. Media executives who realized outrage and fascination are fuels that last longer than dignity. For the people at the center, there was no abstract. The Goldman family, relentless in love and grief, made the public square their office, refusing to let their son be reduced to an asterisk in someone else's story. Nicole's family carried a sorrow that found purpose in advocacy, pushing the country to take domestic violence more seriously. In their faces on talk shows and on courthouse steps, you could read a lesson that trials do not end stories. They redirect them. Years passed. Books were written. Hypotheticals were floated. The Bronco appeared in museums and in jokes. The glove became a shorthand in conversations about courtroom gambits. Young law students watched grainy footage and saw both what to do and what to avoid. The phrase reasonable doubt grew thick with meanings it hadn't carried before. When O.J. later faced legal trouble in Las Vegas over a hotel room confrontation about sports memorabilia, an odd, tawdry echo of the old grandeur, the sentencing judge's voice seemed to carry the weight of two cases, though she swore she separated them. That is the strange reality of fame. It glues the chapters together even when the law insists each book stands alone. What, then, did the trial reveal that we didn't already know? That evidence can be powerful and still vulnerable to human error. That a single compromised witness can contaminate more than a bag of swabs. He can contaminate belief. That juries do not sit in a vacuum. They sit in a country. That domestic violence, for too long footnoted, belongs at the center of our moral mapping. That televised justice is not just justice plus cameras. It is a different creature, with rhythms and incentives that can warp the shape of truth. Ask 10 people what the Simpson verdict meant, and you will hear 10 histories. A victory against systemic racism, a miscarriage of justice, proof that celebrity distorts gravity, proof that jurors can only judge what's brought properly before them. All 10 can be sincere. The trial became a reflection surface, and each of us saw our own face as much as we saw the defendant's. That is why arguments about the case rarely persuade, because they are not about a single night in Brentwood so much as about how we believe the world works. Still, you can make a simple list without betraying complexity. There were two people, a woman and a man, who were savagely murdered. There were children who lost a mother. There were parents who lost a son. There was a man who once outran everyone on the field, standing in a courtroom watching strangers hold his future like a fragile box. There were scientists trying to translate blood into numbers, and lawyers trying to translate numbers into stories. There was a detective who lied and gave the defense a skeleton key to unlock the entire house. There was a glove that hardened into metaphor. There was a nation willing to rearrange its days to watch the next witness take the stand. If you return in your mind to the beginning, the walkway, the body, the dog that whined, you might feel an ache at how many rooms the story would grow to fill. A double murder could have been a local tragedy that flickered out after a week of front-page horror. But here the rooms multiplied. Race and policing, science and certainty, fame and its distortions, the ethics of broadcasting grief, the private violence that so often hides behind public charm. The hallway between the rooms became crowded. The doorways stuck. People bumped shoulders and argued, and sometimes learned, and sometimes hardened. Sometimes, to understand a trial, you follow the evidence. Other times, to understand its meaning, you follow the echoes. The Simpson trial's echoes are everywhere. In how labs lock down their procedures, in how activists point to Foreman as a case study for why oversight matters, in how domestic violence hotlines gained volume, in the reflexive skepticism that greets both breathless prosecutors and swaggering defense counsel, in the way the nation measures beyond a reasonable doubt, not as a math problem, but as a feeling calibrated by history. And yes, there is the uncomfortable fact that even the best story we can tell, assembled from testimony, exhibits, closing arguments, can never perfectly overlay the reality of what happened on that sidewalk. Trials are translations. Something is always lost. The jurors did their work inside the architecture the law built for them, under instructions about burdens and doubts that are meant to guard the innocent at the cost of sometimes releasing the guilty. Whether you believe the verdict was right or wrong, it emerged from that architecture. If you dislike the outcome, you must at least respect the blueprint, or work openly to change it. Toward the end of that long year in court, one of the jurors looked tired in a way that suggested seafaring, as if she had been holding herself upright against waves. When asked later, she said the hardest part was not the restrictions or the boredom, but the knowledge that any decision they made would disappoint millions. That is not supposed to be a juror's burden. The law instructs them to consider only the evidence, not the street outside. But the cameras had made the walls permeable. That we ever expected otherwise was perhaps the original naivete. What finally remains? A memory of television light flickering on office walls as secretaries and mechanics and nurses paused to watch a white SUV float down a freeway. A recollection of a courtroom where a glove wouldn't slide on, and an attorney rhymed his way into history. Families who still grieve. A generation that learned they could be both riveted and repelled by a trial, and that both reactions could be honest. A city that discovered its own fractures and began, haltingly, to set them. Sometimes a story ends with a gavel. Sometimes it never ends at all, it just stops echoing so loudly. The Simpson trial is like that. It hums under other stories about justice, fame, police, science. When a new case hits the airwaves, editors ask, "Is this the next O.J.?" And that question carries a kind of weariness as well as hunger. We keep trying to measure ourselves against a moment that revealed our angles and curves so starkly. If you walk past Bundy Drive today, the sidewalk is just a sidewalk. People jog, dogs sniff, the air does its California thing. The present is so good at pretending it has no past. But if you stop and let your mind return, the night is still there, coiled like a hose beneath the gravel. You can feel the heat of the lights, hear the low murmur of uniforms coordinating, sense the beginning of a tunnel the country would willingly enter. At the other end of that tunnel is a verdict read aloud in a quiet room and a nation that has not, even now, decided what to make of it. So the story you asked for, the no-cut, no-jump version, the one that runs straight from a Sunday in June through a fall afternoon of televised stillness, ends, if it ends at all, with the paradox that drove its power. A case that seemed to promise clarity delivered controversy, and a trial that taught us new science also taught us how little science can soothe when trust is broken. We leave it where it leaves us, in a country still arguing, still learning, still watching the road, wondering what it means when a car moves slowly enough that we can all see ourselves in its reflection. Let's stay with the street, the simple, stubborn geography where all this began, and see if we can walk it to a softer horizon. Because even the hardest stories ask for a way to set them down gently, not to forget them, but to stop letting them bruise us in the same place every time. Imagine the Bundy sidewalk at dusk, years after the trial, the kind of evening when the sun takes its time leaving and shadows get long enough to look like roads of their own. A couple passes talking about groceries. A runner checks a watch. A kid on a scooter bumps over the seams where concrete squares meet. The world has returned to its casual posture. And yet, if you pause, you can still feel the thin hum of what happened, not as a scream anymore, but as a note that belongs to this place. The note does not ask you to decide anything. It only asks you to listen for a moment and then keep going with more care than before. Back then, June to October and then all the years, the country lived at a high pitch. We learned people we loved saw things differently. We learned that doubt is not a defect but a shape the mind takes when it refuses to be rushed. We learned, too, that certainty can be a refuge, sometimes honest, sometimes convenient. In the echo years since, those lessons have settled. They no longer jolt. They guide. A younger generation came up hearing the case as a history lesson, not a live feed. And they keep asking good questions. How do we hold both the power of DNA and the frailty of its caretakers? How do we honor survivors of domestic violence while remembering that trial burdens are calibrated to protect the innocent? How do we keep police work from curdling into a story people can't trust? These are grown-up questions, and they deserve grown-up answers that aren't just slogans. You can picture the people whose names filled headlines as they moved on in time, carrying versions of themselves changed by the spotlight's heat. Marcia Clark writing, teaching, insisting that the weight of evidence needs not only to be heavy, but to be carried correctly. Christopher Darden choosing quieter rooms, then returning sometimes to explain what it felt like to argue while half the country measured his every breath. Johnny Cochran before he left the world, doing what he had always done, making the case that the law must be a living instrument, especially where it meets race and power. F. Lee Bailey and the rest of the defense bar proving, for better and worse, that a coordinated story told confidently can reshape a landscape. Judge Ito disappearing into a different rhythm, his name now a handle on a drawer full of debates about cameras and courts. Detectives and criminalists, some retired, some gone, and a whole cohort of new ones trained in the religion of the chain of custody form. And then there are the families, who don't get to move on in the way we say when we want to tidy our language. They learn to live beside absence, which is the bravest daily skill there is. They built routines around something that does not return. They took their grief public, not because they loved microphones, but because public is where the harm had been amplified. In their steadiness, year after year, you can read a code of conduct for how to carry the uncarryable. Speak, even when you're tired. Correct, when the story turns careless. Refuse to let a courtroom outcome decide your right to remember. They modeled a plain, stubborn love that does not hate loudly, but does not flinch either. The city learned too. Los Angeles is often told it is a place that forgets quickly. But that's a misunderstanding. It is a place that hides its remembering inside motion. The traffic, the industry, the soft churn of surfaces. After the verdict, LAPD policy manuals thickened with procedures that, on the page, look dry. Seals double-signed, gloves changed, swabs cooled on schedule. Evidence rooms logged like vaults. Rookies learned the story as a caution, not a gossip item. Don't give a defense the contour it needs to argue contamination. Don't give a jury the impression you brought your conclusions to the scene, and then gathered only what matched them. In those small disciplines is a kind of apology and a promise all at once. Television, for its part, kept doing what it does, making everything immediate. But there, too, a quieter adjustment took place. Some judges closed their courtrooms. Some producers learned to put experts on air who could explain rather than inflame. Not always. Not enough. But more than before, a handful of anchors discovered the grace of saying, "We don't know yet," and letting that sentence stand without decoration. It turns out humility can be good television if you let people feel how rare it is. And the rest of us? We absorbed the reflex to ask more questions before we feel finished. We learned to hold two truths without letting either cancel the other. That the prosecution presented powerful scientific evidence, and that the actions and testimony of a single detective, proven racist and dishonest on the stand, bled trust in a way that bled everything around it. We learned that a jury can be both conscientious and controversial, that speed in deliberation is not always a sign of carelessness, sometimes a sign of consensus reached in a room that has been listening for months. We learned that if you bring cameras to court, you must bring reverence too, or the lens will bend the line. There is a scene I like to imagine, imaginary but honest in its way. A law student sits in a library with transcripts piled like bricks around them. They're reading a cross-examination from that long trial, and they are not excited. They are patient. They lean back and think not, "Which side was I on?" but "What would have made this clearer, cleaner, fairer?" They write a note to themselves. Always ask the witness one question fewer than you want to. Leave clarity instead of heat. Then they go home, and years later, in a courtroom without cameras, they do their job in a way that leaves the next jury less burdened by avoidable doubt. That's how big cases change small rooms, not by slogans, but by habits. Another scene. A teenager hears a neighbor yelling at a woman behind a door. The teenager remembers Nicole's photos and the 911 tapes, and the way entire years can be prefaced with, "We didn't take it seriously enough." The teenager calls. A patrol car arrives. A report is written that does not trivialize. A referral is made. A shelter answers. The arc of the case bends in that moment toward someone whose name you'll never know because her name gets to stay private and safe. That's how large stories earn their keep, by hovering behind small choices until we make the kinder one. Sometimes the most merciful ending is not a reversal or a revelation, but a settling. Not down into forgetfulness, but into right proportion. The Simpson trial wasn't every story about America. It was one story that illuminated others. It was never a thesis. It was a prism. If you hold it now, years later, and turn it gently in your hand, you'll see, yes, the glare of what went wrong. An investigator whose perjury scorched trust. Theatrics that risked swallowing substance. But you'll also see the wavelengths of what we've done with that glare. Better labs, better training, more suspicious audiences in the healthy way, more attention to the long shadow domestic violence casts. And in that spectrum, there is a color we don't often name, the quiet of acceptance. Acceptance not of harm but of complexity. Acceptance that two people can watch the same tape and carry away different convictions. Acceptance that belonging to a plural country means staying in rooms where unanimity never comes. So we end gently, by stepping off the freeway and back onto ordinary streets. We let the Bronco go where all notable cars go. Into the museum of metaphors we visit less and less often. We stop using the glove as a punchline and let it be what it was, an evidentiary object mishandled into meaning beyond its leather. We allow the lawyers their human sizes again, brilliant, mistaken, persuasive, tired, rather than keeping them as characters we vote for or against. We keep the families in our care, not our curiosity. We hold the science to its highest standards without pretending that math alone can carry the moral weight of trust. And finally, we return to the human center that never needed cameras. Two people who should have grown older and did not. We do something the trial format can't. Sit with that without argument. We let the air be still for them. We understand that justice in the criminal sense was argued and delivered one way, and in the civil sense another, and that neither will ever feel like enough beside a headstone. We give language a rest and let the quiet do the work it is uniquely qualified to do. If you walk, tonight, under some other city's trees, you can finish the story for yourself, not by adding a twist but by adding a promise. You promise to be the kind of person who does not confuse spectacle with truth. You promise to hear the tremor in a neighbor's voice and act. You promise to enter difficult conversations with more interest than certainty. You promise to respect the room where 12 ordinary people make an extraordinary decision, and also to demand the institutions feeding that room be worthy of the choice they ask jurors to make. That is the smoothest ending a rough story gets. Not a bow, not a verdict we can all agree on, but a usable inheritance. The case takes its place on a long shelf labeled "Not Simple." It stands there with other volumes that teach us how to be together without pretending disagreement is a sin. We visit sometimes to remember to adjust our bearings, to teach the young what it costs to learn these lessons. Then we close the cover. We turn off the television light that still glows faintly in the memory. We step back into our lives, which have always been the true venue where justice either happens or doesn't. We carry the quiet with us a few more steps than we used to, and when someone asks how the story ends, we smile in a way that isn't evasive, only kind, and say, "It ends where it must," with us doing a little better, because we insisted on listening all the way to the last word.